G'day everyone, and welcome to the 12th and final week of our Legal Ethics and Trust Accounting course. We're nearly at the end of the journey. To this point, we've basically spent the whole course breaking down the solicitor's conduct rules and to a lesser extent the barrister's rules to give you guidance on how a practitioner must behave, and more importantly, how they must not behave in the course of practice. This week, we bring that discussion to its natural conclusion by looking at what happens if it all goes wrong. We're going to look at the two general categories of misconduct, which we refer to as professional misconduct and unsatisfactory professional conduct. And then we're going to have a look at some of the sanctions that can be imposed in the event that a practitioner is found to have conducted themselves unethically. Let's start by distinguishing in general terms between professional misconduct and unsatisfactory professional conduct. None of this should be new. I've already alluded to it a couple of times during the course. The first thing to understand is that they're not different types of misconduct. The distinction refers rather to the seriousness of the misconduct. Professional misconduct is the worst sort of offending, while unsatisfactory professional conduct is still, unsatisfactory, but it doesn't reach the same level of misconduct as professional misconduct. Having said that, it would be legitimate to suggest that there's some vague equivalent to the criminal law concept of mens rea. If a practitioner knows that they're doing the wrong thing, but they go ahead and do it anyway, that's more likely to be professional misconduct. If they're trying to do the right thing but they get it wrong, that's more likely to be unsatisfactory professional conduct. Even here though, the boundaries are very hazy. In the third video this week, we're going to look at a range of the potential consequences for professional misconduct and unsatisfactory professional conduct. However, as you might expect, the consequences for professional misconduct are at the worst end, reflecting the fact that professional misconduct involves the worst misconduct. So you're much more likely to be struck off the roll or to have your practicing certificate suspended for professional misconduct, and you're much more likely to be required to undertake additional CPD or to pay a fine for unsatisfactory professional conduct. Again though, the boundaries really are hazy. What all of this adds up to is the fact that professional misconduct and unsatisfactory professional conduct are not neat categories to which we can allocate different types of conduct. They're useful concepts, but that's as far as it goes. So let's focus on professional misconduct. This is the older of the two concepts. It's likely that the courts and the Inns of Court for centuries have disciplined lawyers, but it was in the late 19th century that we got a genuine definition in the common law. It came in a case called Allansen and the General Council of Medical Education and Registration. As you can probably guess from the title of that case, this was actually a case arising in the medical profession, not the legal profession. And given that I'm recording this video in early 2022, still deep in the worldwide COVID-19 crisis, it's interesting to note that the actual misconduct Allansen was accused of was encouraging people to avoid what was then the new technology of vaccination. The court had to settle on a definition of professional misconduct because the basis of the appeal was that there were no grounds on which the board could have found that Allansen had engaged in infamous conduct in a professional respect. The definition, attributed to Lord Justice Lopez, was that conduct is infamous in a professional respect if the professional, in the pursuit of his profession, has done something with regard to it which would be reasonably regarded as disgraceful or dishonourable by his professional brethren of good repute and competency. This has become known as the Allinson Test, and it's still influential. The Allinson Test is, however, somewhat problematic in a couple of ways. First, the relevant standard is that of the profession. But part of the meaning of a profession is a willingness to serve the public. And yet, the standards and expectations of the community don't find a place in the Allinson definition. Perhaps more importantly, the standard is set very high, You don't have to work too hard to imagine misconduct which would be improper, but still not reach the standard of being disgraceful or dishonourable. And so eventually the Parliament, as the representative of the community, established a statutory definition. Section 419 of the Legal Profession Act 2007 gives an inclusive definition of professional misconduct. So it doesn't exhaustively define professional misconduct, but it does put some shape on it. The test has two limbs. First, it's professional misconduct to exhibit a substantial or consistent failure to reach or keep a reasonable standard of competence and diligence. So, a mere failure to reach a reasonable standard of competence or diligence isn't enough. For professional misconduct, we need to see a substantial or consistent failure. Second, it's professional misconduct to do anything, whether in the course of practice or otherwise, that would justify a finding that the practitioner was no longer a fit and proper person to be practicing. These rules make somewhat more sense if they're supported by examples, so I've pulled out a couple of examples from relatively recent professional conduct matters before QCAT and the courts. I need to emphasise, in all fairness to the practitioners, that these are not authorities. I haven't pulled them out to highlight these practitioners as against other practitioners who might have engaged in similar conduct or faced similar findings. They're no more than examples. Let's start with the first limb. In a case called the Legal Services Commissioner against Fajardo, the practitioner represented her client in a misappropriation case for which he was convicted. Now, during cross-examination, the client claimed to have arrived in Australia when he immigrated some years before with $500,000 in cash. However, in her written submissions, Ms. Fajardo argued that there was no evidence of him having had this cash. Obviously, that wasn't true. His own testimony was the evidence. QCAT found that she had not corrected the record and that the significance of the error was such that this should be considered professional misconduct. She had misled the court in a very substantial way and failed to correct the record. Professional misconduct. As an example of the second limb, we can turn to the Legal Services Commissioner and Ferguson, a very recent 2021 case. Mr. Ferguson pleaded guilty to the possession of child exploitation material, which is a polite legal term for child pornography. He was convicted and sentenced to 18 months in prison. Now, there was no connection between his offending and his position as a legal practitioner, but it's still quite obviously the case that someone who disregards the law and outrages the community by committing offences such as these can no longer be regarded as a fit and proper person to be an officer of the court. So, there's professional conduct. I really want you to remember three things. The Allinson Test, reasonably regarded as disgraceful or dishonourable. The first statutory limb, substantial or consistent failure. And the second statutory limb, not fit and proper. In the second video this week, we're going to go on and look at unsatisfactory professional conduct. Just 3 videos left in the whole course. See you in video 2.